Hello friends and welcome to my channel Indus Educare.
And today we are going to see some important MCQs on Criminal Procedure Code, that is CrPC 1973. So let's begin. The first is Section 162 of the Code of Criminal Procedure 1973 is for the protection of option A, accused, option B, witnesses, option C, police officer, and option D is magistrate. The correct option is option A, accused. Next, the protection under section 162 of the Code of Criminal Procedure 1973 is option A, available in civil proceedings, option B, available for proceedings under Article 32 and or 226 of the Constitution, option C, not available in rape cases, and option D is only available in criminal inquiry or trial in respect of the offence under investigation. The correct option is option D, only available in criminal inquiry or trial in respect of the offence under investigation. Next, under the provisions of Code of Criminal Procedure 1973, confessions, option A, can only be made to the authorized persons. Option B, only the magistrate enjoys the power of recording confessions. Option C, made to the police officer are valid. And option D is made by the accused while in police custody to a police officer is valid. The correct option is option B, only the magistrate enjoys the power of recording confessions. Next, which of the following statement is not true under the provisions of the section 167 of the Code of Criminal Procedure 1973? Option A, the provision for release is mandatory in the sense that the accused shall have to be released on bail. Option B, magistrate has the power to remand accused, that is terrorist, to army custody for investigation. Option C, the order under this section is a judicial order. And option D is on the expiry of 60 days from the date of the arrest of the accused, the further detention does not ipso facto become illegal. The correct option is option B, magistrate has the power to remand accused, that is terrorist, to army custody for investigation. Next, which of the following is true of section 31 of CrPC? Option A, it relates to the quantum of the punishment that the court has jurisdiction to pass where the accused is convicted of 2 or more offences at one trial. Option B, it is rule of the procedural law. Option C, either option A or option B. And option D is both option A and option B. The correct option is option D, both option A and option B. Next, the term taking cognizance under the provisions of Code of Criminal Procedure 1973 means option A, starting a trial, option B, completing preliminary requirements for starting a criminal trial, option C, taking notice of the matter judicially, and option D is an administrative action to decide if criminal trial is required. The correct option is option C, taking notice of the matter judicially. Next, which of the following requirements need not be followed under section 200 of the Code of Criminal Procedure 1973? Option A, the complainant must be examined. Option B, examination of the complainant must be under oath. Option C, the accused must be given an opportunity to be heard. And option D is the examination of the complainant must be reduced to writing. The correct option is option C, the accused must be given an opportunity to be heard. Next, the magistrate, under the provisions of Section 203 of the Code of Criminal Procedure 1973, can dismiss a complaint. Option A, even if the proceedings against the accused have commenced. Option B, even if there is sufficient ground for proceedings. Option C, even if inquiry under Section 202 results no ground for proceedings. And option D is even if the complainant is not examined. The correct option is option C, even if inquiry under Section 202 results no ground for proceedings. Next, which of the following statements hold true for plea of guilty under the provisions of the Code of Criminal Procedure 1973? Option A, the plea of not guilty is not recognized by CrPC. Option B, pleader can make plea of guilty on behalf of the accused. Option C, the admission made by the accused is binding on him. And option D is plea of guilty to a capital charge is inadmissible. The correct option is option A, the plea of not guilty is not recognized by CrPC. Next, under Section 239 and 240 of the Code of Criminal Procedure 1973, 1. Reasons must be given if the accused is discharged. 2. Reasons must be given if the charges are framed against him. 3. Hearing includes hearing of evidence if needed. Option A, 1 and 2. Option B, 1 and 3. Option C, 2 and 3. And option D is only 3. The correct option is option B, 1 and 3. Next, under Section 243 of the Code of Criminal Procedure 1973, option A, a magistrate cannot issue summons to the complainant for being examined as a witness of the accused. Option B, the court cannot ask the accused to deposit expenses which might be incurred by the witness. Option C, at the instance of the accused, the complainant can be resummoned. And option D, all of the above. The correct option is option A, a magistrate cannot issue summons to the complainant for being examined as a witness of the accused. Next, which of the following statements does not hold true under Section 246 of the Code of Criminal Procedure 1973? Option A, the magistrate can exercise his discretion to allow cross-examination or not. Option B, the accused cannot cross-examine the witness for the prosecution before the charges are made. Option C, if the accused pleads guilty, magistrate is bound to record the plea. And option D is, if the accused pleads guilty, magistrate is not bound to convict him. The correct option is option B, the accused cannot cross-examine the witness for the prosecution before the charges are made. Next, which of the following statements hold true under Section 248 of the Code of Criminal Procedure 1973? Option A, the magistrate does not have power to discharge the accused. Option B, this section will apply when some evidence has been let in and such evidence is not satisfactory. Option C, this section does not apply in the case of prosecution cannot produce any evidence. Option D is, the magistrate does not have power to pass sentence on the accused. The correct option is option B. This section will apply when some evidence has been let in and such evidence is not satisfactory. Next, discharge of accused under section 249 of the Code of Criminal Procedure 1973, option A, is considered to be acquittal for purpose of section 300 of CrPC. Option B is based on the merits of the case. Option C acts as a bar on filing second complaint. And option D need not be done in case of complainant dies. The correct option is option D, need not be done in case of the complainant dies. Next, the order of compensation under section 250 of the Code of Criminal Procedure 1973 can be made, option A, in cases where the offences are compounded. Option B, where discharge or acquittal is not made. Option C is by the magistrate only where the offence charge is triable by him. And option D, by the successor in office. The correct option is option C, by the magistrate only where the offence charge is triable by him. An order under dash of the Code of Criminal Procedure 1973 acts as a bar under section 300 of the Code to the trial of the accused for the same offence. Option A, section 256. Option B, section 203. Option C, section 227. And option D is section 239. The correct option is option A, section 256. Next, the magistrate as his discretion can allow the complainant to withdraw the complaint and acquit the accused in case of option A, warrant case, option B, summons case, option C, both option A and option B, and option D is neither option A nor option B. The correct option is option B, summons case. Next, for the application of section 300 of the Code of Criminal Procedure 1973, it is not necessary, option A, that there must have been a previous trial of the accused. Option B, for the accused to be acquitted in the previous trial. Option C is for the previous proceedings to have been for an offence. And option D, for the second trial to be for the same offence. The correct option is option B, for the accused to be acquitted in the previous trial. Next, who amongst the following is not competent under section 92 of CrPC to order the postal or telegraph authority to deliver the documents or things? Option A, district magistrate. Option B, judicial magistrate. Option C, metropolitan magistrate. And option D, none of the above. The correct option is option B, judicial magistrate. Next, the word inspection used in section 93 of A of CrPC refers to option A, things or documents. Option B, locality and place. Option C, both option A and option B. And option D is either option A or option B. The correct option is option B, locality and place. Next, a search warrant can be issued in respect of a place. Option A, used for deposit and sale of stolen property. Option B, used for deposit, sale and protection of counterfeit coin, currency notes and stamps. Option C, used for deposit, sale and protection of forged documents and false sales. And option D is all of the above. The correct option is option D, all of the above. Next, Section 87 of CrPC authorizes issuance of warrant, option A, in lieu of summon, option B, in addition to summons, option C, both option A and option B, option D, none of the above. The correct option is option C, both option A and option B. Next, a declaration of forfeiture under Section 95 of CrPC can be set aside by option A, magistrate issuing the search warrant, option B, chief judicial magistrate or chief metropolitan magistrate, option C, court of sessions, and option D is high court. The correct option is option D, high court. Next, search without warrant can be conducted under Section 103 of CrPC. Option A, in the presence of the magistrate who is competent to issue search warrant in respect of any place. Option B, in the presence of the magistrate who is not competent to issue search warrant in respect of any place. Option C, both option A and option B, and option D is neither option A nor option B. The correct option is option A, in the presence of magistrate who is competent to issue search warrant in respect of any place. Next, joining up two or more independent and respectable inhabitants of the locality in which the place is to be searched is the mandate under option A, Section 100 of 1 of CrPC, option B, Section 100 of 2 of CrPC, option C, Section 100 of 3 of CrPC, and option D is Section 100 of 4 of CrPC. The correct option is option D, Section 100 of 4 of CrPC. Next, Sections 39 and 40 of CrPC make it mandatory to give information regarding commission of certain offences. Such information can be given to option A, a magistrate, option B, a police officer, option C, either to a magistrate or to a police officer, and option D is the magistrate and the police officer both simultaneously. The correct option is option C, either to a magistrate or to a police officer. Next, when a police registers a case regarding commission of a cognizable offence, the registration of the case is under option A, Section 154 of CrPC, option B, Section 155 of CrPC, option C, Section 156(3) of CrPC, and option D is Section 190 of CrPC. The correct option is option A, Section 154 of CrPC. Next, usually a copy of F.I.R. is filed with magistrate having jurisdiction to take cognizance by the police officer in compliance to option A, Section 156 of CrPC, option B, Section 157 of CrPC, option C, Section 158 of CrPC, and option D is Section 159 of CrPC. The correct option is option B, Section 157 of CrPC. The investigating police officer in a case has power to require attendance of a person acquainted with the facts and circumstances of the case under option A, Section 158 of CrPC, option B, Section 159 of CrPC, option C, Section 160 of CrPC, and option D, Section 161 of CrPC. The correct option is option C, Section 160 of CrPC. Next, Section 156 of 2 of CrPC takes care and cures. Option A, any irregularity in the conducting of investigation by the police officer. Option B, any illegality in the conducting of investigation by the police officer. Option C, both option A and option B, and option D is only option A and not option B. The correct option is option C, both option A and option B. Next, under section 159 of CrPC, a preliminary inquiry into the commission of offence can be conducted. Option A, by the magistrate having jurisdiction to take cognizance. Option B, by any magistrate subordinate to magistrate having jurisdiction under the orders of such magistrate. Option C, by the police. And option D, only A and option B. The correct option is option D, only option A and option B. Next, the powers under section 159 of CrPC can be exercised by the magistrate. Option A, when the police is still investigating the case. Option B, when the police decides not to investigate the case. Option C, when the police has filed the report under section 173 of CrPC. And option D, all of the above. The correct option is option B, when the police decides not to investigate the case. Next, the investigating officer under section 160 of CrPC cannot require the attendance of a male at a place other than the place of his residence who is option A, under the age of 15 years, option B, under the age of 16 years, option C, under the age of 18 years, and option D, under the age of 21 years. The correct option is option A, under the age of 15 years. Next, under section 159 of CrPC, the magistrate has the power to option A, direct investigation by the police. Option B, dispute any magistrate subordinate to him to hold a preliminary inquiry. Option C, either option A or option B, and option D is only option B and not option A. The correct option is option C, either option A or option B. Next, section 160 of CrPC authorizes a police officer to option A, summon a person as a witness. Option B, summon a person for the production of documents. Option C, summon a person for the production of an article. And option D is all of the above. The correct option is option A, summon a person as a witness. Next, a person can be summoned as a witness under section 160 of CrPC by option A, any police officer. Option B, the station house officer. Option C, an investigating officer. And option D, any of the above. The correct option is option C, an investigating officer. Next, laying of trap is a part of option A, investigation. Option B, inquiry. Option C, preliminary inquiry. And option D, trial. The correct option is option A, investigation. Next, statement made under section 161 CrPC during the investigation of a cross case is option A, always admissible in the main case. Option B, may be admissible in the main case. Option C, not at all admissible in the main case. And option D is admissible in the main case with the leave of the court. The correct option is option C, not at all admissible in the main case. Next, Procedure: when corporation or registered society is an accused is given in option A, section 305 CrPC, option B, section 387 CrPC, option C, section 280 CrPC, and option D, section 289 CrPC. The correct option is option A, section 305 CrPC. Next, under section 320 of 1 CrPC, for wrongfully confining a person for 10 days or more, which section of IPC is applicable? Option A, 348, option B, 340, option C, 342, and option D, 344. The correct option is option D, 344. Next, which of the following deals with the procedure where court considers that case should not be dealt with under section 345 CrPC? Option A, section 339 CrPC, option B, section 287 CrPC, option C, section 388 CrPC, and option D, section 346 CrPC. The correct option is option D, section 346 CrPC. Next, which section of CrPC states that warrant issued by Magistrate of India may be executed at any place in India? Option A, section 57 CrPC, option B, section 67 CrPC, option C, section 77 CrPC, and option D, section 87 CrPC. The correct option is option C, section 77 CrPC. Next, of the three clauses of subsections 2 of 1 of section 82 CrPC, option A, clause A and clause C are conjunctive and clause B is not disconjunctive. Option B, clause B and C are conjunctive and clause A is not disconjunctive. Option C, clause A and B are conjunctive and clause C is not disconjunctive. And option D is clause A, B and C are conjunctive and not disconjunctive. The correct option is option D, clause A, B and C are conjunctive and not disconjunctive. Next, discharge of offender on submission of apology is covered under option A, section 339 CrPC, option B, section 348 CrPC, option C, section 388 CrPC, and option D is section 458 CrPC. The correct option is option B, section 348 CrPC. Next, under section 320 of 1 CrPC, for dishonest misappropriation of property, which section of IPC is applicable? Option A, 404, option B, 402, option C, 401, and option D is 403. The correct option is option D, 403. Next, which of the following cases held that there is no conflict between section 107 and 145 of CrPC? The words in section 145 are mandatory while the language of section 107 is discretionary. Option A, Baljit Singh versus Bhoju Ghosh, 1907-35, Calcutta 117. Option B, Sham Charan Chakravarti versus Katu Mandal, 1897-24, Calcutta 344. Option C, Kalikishan Tagore versus Anand Chandar Rai, 1896-23, Calcutta 557. And option D, none of these. The correct option is option A, Baljit Singh versus Bhoji Ghosh, 1907, 35, Calcutta, 117. Next, which of the following provides for the right of person against whom proceedings are instituted to be defended? Option A, Section 265 CrPC. Option B, Section 387 CrPC. Option C, Section 303 CrPC. And option D is Section 289 CrPC. The correct option is option C, Section 303 CrPC. Next, power of High Court to confirm sentence or annual conviction is provisioned under option A, Section 350 CrPC. Option B, Section 368 CrPC. Option C, Section 365 CrPC. Option D, Section 289 CrPC. The correct option is option B, Section 368 CrPC. Next, which of the following deals with the procedure in case of difference of opinion? Option A, Section 350 CrPC. Option B, Section 287 CrPC. Option C, Section 365 CrPC. And option D is Section 370 CrPC. The correct option is option D, Section 370 CrPC. Next and the last, which of the following deals with appeal from orders under Section 446 CrPC? Option A, Section 286 CrPC. Option B, Section 449 CrPC. Option C, Section 388 CrPC. And option D, Section 500 CrPC. The correct option is option B, Section 449 CrPC. Thank you and good luck for your better future.